Welcome, everyone. I am Joanne Hughes. I'm the Capacity Development Coordinator for the Ontario Federation of Agriculture. There is a lot of people online today. Thank you and welcome. The weather is perfect for a lunch and learn meeting. You're not wasting your days inside when the sun's shining. Yesterday was beautiful, but today is pretty great for everything drainage. The number of attendees is really high, so I would like it if everyone waited to the end of the presentation to ask questions. Just raise your hand and take yourself off mute and you can ask a question, or we will also be monitoring the chat during the presentation. So if you put a question in the chat, we will do our best to get to as many questions as possible. But as I said, we have a high number on this call today. So if we don't get to your question, we will have contact information for the speakers. So if you have questions, you are more than welcome to reach out to either Tim or Tina. So at this point, I would like to shift the meeting over to Tina. Tina is part of our policy team at OFA.
Good afternoon, everyone. It's great to see how many people have already joined us and are continuing to sign on. As Joanne said, I am Tina Shankula. I'm in the policy department with OFA. I've worked for OFA for 27 years now, and I handle files, pretty much the files related to water come to me. So obviously includes drainage. But more importantly, I'd like to introduce our speaker today, who is Tim Brook. Tim has been working in the water industry for the past 24 years in both private and public sectors. He is a licensed professional engineer and holds both a bachelor's and a master's degree in engineering. In his various roles with the Ontario Ministry of Ag, Food and Rural Affairs, OMAFRA, Tim has worked with various stakeholders on water management and drainage topics. He is currently OMAFRA's Drainage Program Coordinator, where he provides program leadership, oversight, and engineering expertise to the Drainage Act, Agricultural Drainage Infrastructure Program, the Ag Tile Drainage Installation Act, and Tile Drainage Act. So I will turn the meeting over to Tim to share his expertise with us today.
Thank you, Tina. Good afternoon, everyone. Glad you can join me here, and I hopefully you'll find this useful. So my premise of what I wanted to walk through is sort of a drainage 101, having talked with both Tina and Joanne, but I really want to focus in on how it relates to you, the farmers, the farm community. So I'm going to try to make it hopefully directly relatable to what you guys experience and do on your day-to-day on the farm. I won't spend time here, but basically I want to walk through all of these different things, giving you a little bit of an overview of our legislation, and then really honing in on what does it mean to you, and then getting into some common questions and drainage conflicts, which is also something that's important, I know, across the landscape, and I have a lot of individuals call me often to try to help give information on how they can navigate some of those conflicts and other specific questions. So provincially, drainage is very, very essential, and I know that you guys all know that. It's important for agriculture, it's important for roads, but also residential, commercial, industrial properties, and it's important in urban and rural settings. Without water drainage, our current society would have challenge functioning the way it functions. And it's important to note up front that it's, there we go. It's a complex issue, and it can be very contentious because it deals with property rights. It deals with conflict often between neighbors, and really people have to work together to solve drainage needs. It's hard to solve one particular property's drainage needs without potentially impacting the neighbor. And really it's a complex task of balancing the needs, as I mentioned, as well environmental and societal interests. Regulatory compliance is an important piece of drainage today. And then obviously ongoing maintenance needs for that infrastructure should be addressed as well, so that these systems that are put in place can function for a long time and provide the value and benefit that they're expected to deliver. So a whole bunch of factors affect drainage, and that includes how big is your watershed, your soil type, is there water coming from upstream properties, and really getting into how do you design these systems to actually provide value to deliver the services that are necessary. Drainage really is a combination of systems, both private ownership, so private drainage systems, as well as communal drainage systems. And we'll talk more about those under the Drainage Act. And then ultimately, natural water courses provide outlet for all of these systems eventually into the Great Lakes Basin for most of southwestern Ontario. It's important to note that we talk about private drainage systems. We're going to get into more details around what those look like, specifically roadside ditches and things like that. But some private drainage systems are owned and operated by the municipality. So when I say private, I generally mean things that aren't covered under the Drainage Act as a communal system, because municipalities, including roadside ditches and some urban stormwater systems that are regulated under the Ontario Water Resource Act, are still private drainage systems meant to provide drainage for specifically a piece of infrastructure that they serve. So as I mentioned, when I talk about private drainage systems, we're going to talk about a number of things, but what I want to predominantly talk about are the private agricultural drainage systems that are installed across fields in Ontario to improve crop productivity. These are important to get on the fields early. They're important to create optimized crops, uniform harvest. There's a lot of valuable services that these systems provide. And they obviously require what we call legal and sufficient outlet. I'm going to talk about more about that as we get into things. But these legal and sufficient outlets can include natural water courses, drains under the Drainage Act. They can include roadside ditches in some cases. And so it's really important to consider where your water goes before you actually collect it and build your system. So you want to know where it starts on your field, how to collect it, and how to get it safely and legally off of your field downstream. Bit of context here, there are approximately 1.9 million hectares of tile drained land in Ontario, and that's out of approximately 3.6 million hectares of cropland in total. So around 60% of all cropland has tile drainage systems installed for crop production. Give a little bit of perspective here on natural water courses. These exist across the province, and they are used for a variety of purposes, including outlet for agricultural drainage, and they are captured under the common law. And I'm going to talk a little more about common law coming up in my presentation. And these natural water courses exist unless they're modified by pieces of legislation such as the Drainage Act, and we'll talk about what that looks like as well. So on the bottom, you can see two different quick captures from our AgMap system. The one on the left, you can see that there are very few drains, the drains being those that are in yellow. There's a couple there, the Mackenzie Municipal Drain as an example, but there are blue water courses on that mapping system. And so those are the natural water courses generally that we've just talked about, the yellow being drains under the Drainage Act. And in contrast, you'll see other parts of the province where pretty much every single water run is a drain under the Drainage Act. And these are really important to understand because there are some legal differences between natural water courses and drains under the Drainage Act. And we'll get into that a little bit. So it's important to understand those differences to understand how those affect the outlets that you can access for your farm drainage systems. In terms of the drains under the Drainage Act, for some context, again, there are about 50,000 kilometers of drains constructed under the Drainage Act across the province. And the use and the density and the types of systems that are there really vary across the province. So I just grabbed Chatham, Kent, Bruce, and Grey counties and Ottawa as a quick example. You can see Chatham, Kent accounts for approximately 8% of the total length of drains in the province. As I mentioned, that picture on the last slide where every single water run was a drain was from Chatham, Kent. So they're very extensively drained with drains under the Act. Whereas if you go to Bruce and Grey, you can see that Bruce County has a fair bit, particularly in the south, not so much on the escarpment in the north. Grey County, right next door, does not have as many drains. So it really varies across the province, and where you're located will really determine what you can use as an outlet for your private ag systems. In terms of stakeholders on the province-wide scale, we have a number of them that we partner with. Obviously, you as the landowners and the farmers are very important stakeholders as the users of drainage. But we also have other stakeholders such as drainage engineering firms, drainage superintendents, and tile drainage contractors. And I'll talk a little bit more about each of these as we go forward. But it's important to understand that these are all individual entities that work in the drainage realm to provide services, whether it's installing private ag systems on farmland, whether it's maintaining those drainage systems under the Drainage Act or designing them as the superintendents and the engineers do. We all have different roles to play. So a quick little overview of OMAFRA's legislation and how it applies across the field. Generally speaking, I'm going to start in the right corner and we'll get into a little more details on this. The Agricultural Tile Drainage Installation Act covers the regulation of the installation of agricultural drainage systems on agricultural land. And it's a process in which OMAFRA regulates these businesses, the machines, and the individual operators that provide those services to farmers. It's important to note that a farmer can choose to install their own drains on their own land, and they're exempt from the act, but contractors are required to follow this licensing legislation. So we issue licenses, as I mentioned, for those 3 different processes. And as far as the stakeholders go, it's important that there's a number of contractors that work across the province. They're spread out throughout southwestern Ontario and also in the north. And they're represented by the Land Improvement Contractors of Ontario, which is an association of contractors that help support the industry with best management practices and making sure that services are available in the best possible manner for the farmers' systems. If we move up into the right corner, you'll see the Tile Drainage Act, and this is really a program about tile loans. Not going to spend a ton of detail here. I have a couple of slides in the future, but again, this is about a financing mechanism available to farmers to get a loan through the local municipality to help fund the installation of these private agricultural drainage systems. So that's on the private landscape side of things, on the individual farms. We move across to the left-hand side, we have the Drainage Act and the Agricultural Drainage Infrastructure Program, which is a grant program under the Drainage Act. And what I just want to talk about here quickly before I move on is that this is the outlet systems for these private drainage systems. You may have a natural water course, you may have a drain accessible to your property, and so it's important again to understand those differences, and we'll get into them. If you do not have access to a natural water course, the Drainage Act is a mechanism to allow you to gain access to an outlet. And we'll talk a bit about that coming up. So going back on the private drainage side, the Agricultural Drainage Installation Act. And so first, what is agricultural drainage? It consists of lateral drains installed across a field to collect water and manage that water table so that excess water can be efficiently moved from the root zone and allow for proper root and crop production. As I mentioned, it also affects field trafficability in the spring, yields, uniform harvest. There's a number of benefits and values that these types of systems provide. And again, once that water is collected, it is important to make sure you have a legal and sufficient outlet for that. So as I mentioned, farmers can install systems on their own properties. However, OMAFRA certainly recommends considering hiring a licensed contractor to design and install those systems. These are contractors that are certified through our licensing process. They have training that OMAFRA through Ridgetown College provides as a licensing requirement, and they also have a number of hours spent on the machine supervised by an appropriate Class A operator. So that's sort of generally our recommendation, but again, farmers can install on their own properties as well. The Drainage Guide for Ontario is a particular resource, publication 29, to highlight here. This is the sort of best management practice for drainage. It also is referenced in the legislation, so individual contractors need to be aware and follow the guide itself as far as designing and installing the systems that they put in place on agricultural land. So that's a very important resource. Even if you're doing it on your own property, we highly recommend being familiar with that material in the publication so that you can do the best job that you can for your own system. And as I mentioned, the legal and sufficient outlet is absolutely critical, and it's critical before you install the laterals, before you start collecting that water. It's important to understand where that water can go legally and will it get there and go downstream without causing damage to other individual properties. And as I mentioned, there's a number of those outlets that are available: natural water courses, drains under the act, roadside ditches. And then certainly the illegal outlet situations, outlet at the property line is not one we're recommending. But unfortunately, sometimes properties are outletted that way, which causes conflict, as I mentioned earlier, between neighbors. So a little more details on the act itself, not as relevant to this crowd, but it does set out that legal framework, as I mentioned, to license the contractors, and we issue licenses to contractor businesses, machines, and individual operators with training requirements. My colleague Andy Kester, as our drainage inspector, does go out and do various inspections. He inspects machines, he inspects the businesses, and he also does inspections on individual operators. One of the things that I would suggest for this audience in terms of what to look for if you're going to hire a contractor is you're going to want to make sure that they are a licensed contractor. So ask when you get them out on site, are they licensed? Can you see a copy of their business license? Does it have the validity in terms of the dates? Are they currently licensed with OMAFRA? And that's really important because you want to make sure that you're hiring a licensed contractor to do the work. That means that they're up to date, they're current with everything that they need to do. As well, if you are going to potentially access a tile loan, the tile loan program requires that the work is done, if by a contractor, the contractor must be licensed at the time of installation. So it's very important to ensure that your contractor that you're hiring is currently licensed at the time of doing the work. To give a little bit of perspective, you can see across the map, those red dots are where the tile drainage contractors are across the province. So depending where you are, you're a little more dense of selection. But some contractors do carry a fair bit of coverage area. So you can obviously go on OMAFRA's website and find some contractors in your area to look at getting some quotes or some information about how they would install on your property. And as far as contacts, there are about 90 active businesses doing this work across the province, and they employ about 400 operators who do the work with about 200 machines. So it's a fairly extensive industry that does a lot of work across the province on a day-to-day basis. So as I mentioned, the Tile Drainage Act is basically a piece of legislation that authorizes the tile loan program, and this provides owners of agricultural land with access to loans for the installation of their systems. And it's through the local municipality. So OMAFRA partners with the local municipalities. And this has been going on since about 1878 when the Tile Drainage Act was put in place. The general process for you as a property owner, as a farmer, is to go out to your local municipality, determine if they offer the program, and if they do, apply through the municipality for your loan. They have the paperwork in place for that and provide the support in terms of what is required and how to do that. Once that is approved, then the work can be completed on the farm to install the system. And the municipality provides the inspection and certification of the work. So the work was done, who has completed the work. It's important to note here that individual farmers can do the work on their own property and apply for a tile loan. Again, the exemption has to apply that it's on your own property, the same as the act itself. The municipality then sells a debenture directly to the province, who funds the process through the municipality to the applicant. And the municipality then passes a bylaw to allow for that money to flow to the property owner, as well as authorizing the annual repayments that are then collected and submitted back to OMAFRA to repay the loan. The current terms of the loan are a 10-year fixed term loan at a 6% interest rate. And currently it is set at a loan of up to 75% of the cost of the work, up to a maximum of $50,000. That's been in place for a little while with the current conditions. Some of the advantages of the tile loan program for farmers is that it's a quite straightforward, well tested process. So the application to the municipality and then the municipality works with us works pretty smoothly. It is an alternative source of financing available, but again, it is limited by the $50,000 maximum, which may be a bit of a concern in some cases. It's a 10-year amortization period, but a few of the other advantages are that redemption can be made at any time without penalty. So it's a simple interest calculation, and redemptions can be made any time that the property owner would desire to, or they can continue for the entire 10-year amortization period. And it's an advantage from the municipality as well as OMAFRA's perspective because they are secured. They are deemed essentially the same as property tax. So essentially you're adding this particular repayment process as a property tax type of payment. On the bottom of the screen, you'll see the last, I think about 8 years or 10 years of tile loans in terms of what's done across the province. And so you can see in general, the decreased use of this program since about 2008 to current. Currently, we have about 50 projects per year, generally speaking, the last couple of years. You'll see the stats there in terms of the drainage acres as well as the total cost of these loans going down a little bit over the years. There may be some reasons as to why the interest rates were quite low the last number of years. That may make 6% less attractive. However, it is becoming more perhaps attractive in the current interest environment. Okay, so I want to then switch a little bit to common law, and this sort of sets the stage for the Drainage Act and then more about conflict and potential neighbor relations issues. So generally, common law is a set of rules and principles that are applicable across Canada with the exception of Quebec. And it's really founded on the process that water that flows naturally should be permitted to continue. And there's two distinguishing types of water under the common law. One is natural watercourse, and the other is surface water. And so I just have a couple of slides here to talk about each one of those. But essentially, the natural watercourse comes along with riparian rights. So as a natural watercourse property owner, you have a right of drainage into that particular water body. You have the right to use the water domestically. But there are some responsibilities that also come. So you must also accept the water that comes in that natural water course, even if it results in flooding of your property. And there's some responsibility and privileges as well that under the common law, an owner is allowed to also modify that channel within the property limits without having negative impacts. It is important, though, to understand that that's under the common law. And so if someone is going to modify a natural water course, they also have to adhere to any legislation that exists. So, for example, the Conservation Authorities Act, Fisheries and Oceans Canada has legislation as well. And so it's important that while you have that right, you want to make sure you're touching base with those regulatory agencies if you're going to work and modify a natural water course. So again, this is where you have a natural water course on your property. As a farmer, the outlet would likely be to this natural water course. You have the right to access it and use it for the outlet of your tile drainage systems. In contrast to that, we have surface water. I tried to denote that a little bit with some of the pictures. You can see the rainwater falls across that farm, pools a little bit, but really doesn't flow in a defined bank and bed type of channel. And so this is surface water. And it really has no inherent right of drainage. So it's certainly going to collect in the low areas. It may even flow across your property boundary to your neighbor, but it doesn't have the right of drainage under the law. And so the lower owner does not have to accept this water. They can berm their property, they can protect it and not accept your water, which of course creates a bit of a problem now that you don't have an outlet for your farm property because it doesn't drain through a natural water course and the neighbor can berm that particular water. So a few things to consider here is if I'm having collected or uncollected water, really talking about the liability issues. So if I'm not collecting this water and the flow of the water is going across my neighbor's property, likelihood of a lawsuit of causing damage to my neighbor is pretty minimal. However, if I'm collecting it through, for example, an agricultural tile drainage system and discharging it onto my neighbor, there may be some grounds for a lawsuit. So it's that collection versus uncollection. And then it's important to just reference here a prescriptive right of drainage. So as I mentioned, surface water has no right of drainage inherently. If though surface water is collected and deposited on a lower landowner, and that's been uncontested for 20 years, it's possible that a prescriptive right exists where the neighbor now has to accept that water and the water continues to flow the way it always has for that 20 plus years. But it's important to note that only a judge can actually grant that prescriptive right. So we're going to touch on that a little bit when we get into the conflict between neighbors. So as I mentioned, this is the common law piece and it always exists. It's kind of the bedrock, if you will, across the landscape unless modified by things such as the Drainage Act. And it's important to note that there's no agency assigned under common law for resolution of these drainage issues. It's really a court-based system or a mutual agreement type of system between neighbors. And so it gets quite challenging sometimes or messy. And so the Drainage Act itself was passed to provide property owners with a way to resolve those drainage problems that can't be resolved by discussions between neighbors or the court systems themselves giving orders or resolution to these problems. So a quick little overview of the Drainage Act. It is enabling legislation that allows for the solution of private drainage issues. It's water-based in approach, so it's comprehensive, and it's administered by the lower tier municipality. So in essence, through a petition process, the municipality would appoint an engineer, and they would look at resolving this drainage issue. So you can construct new drains through that petition process. You can also improve existing drains if there's a change in the landscape or you need to drain deeper to allow access to your tile drainage system that you might be wanting to put in on agricultural land, etc. And it's a system in which the professional engineer designs the system. They implement a cost sharing scheme. So through an assessment schedule, they determine how the cost should be fairly distributed amongst all of the property owners across the watershed. And it really is a process that is meant to be cooperative in that there is a lot of opportunity for property owner input. And there's also appeal mechanisms as well. Really, at the end of the process, what happens is the drain is authorized by this process. It's protected by bylaw that adopts the engineer's report. So again, that engineer's report defines what does the drain look like, where is it, how deep is it, etc. And also the cost sharing mechanism, as I said. So the drain would have legal existence. It's recognized as part of the municipality's infrastructure, and it really authorizes the municipality to maintain and repair that system to keep it working for the benefit of all of the property owners in the watershed. And what this really does is it allows properties that need outlet for their drainage system, so the private agricultural systems, the tile drainage systems that are put in, who are not riparian owners, to allow for a drain to be constructed across private property to give that outlet as if they were riparian owners. Because in essence, now they're riparian owners to this drain under the Drainage Act, and they can then legally discharge their water into the drain if they didn't have that outlet before. So there's a number of processes under the Drainage Act where farmers can be involved. So again, petition for creation of a new drain. You may petition yourself if you need a drain, or you may be finding yourself that your neighbor petitioned for a drain and you're involved in that petition drain process. As well, there's a number of processes for existing drains. So if you're already in the watershed of an existing drain, there might be some improvement projects that a landowner requests. You might want to request as well. We'll touch really briefly on those. There's some major and minor improvement processes, as well as maintenance projects for these existing drains. So if you have a drain that you're outletting to and you're feeling like the drainage is no longer adequate and there's a lot of sediment buildup, there is the ability to maintain those drains through requesting that the municipality come out, inspect the drain, and authorize a maintenance project for that. As well, there's abandonment requests and assessment schedule updates. So I'm not going to go into detail on this slide. This just shows you a little bit of the overall view of how to create a new drain. You can see it's quite extensive. So OMAFRA has some resources to assist the engineers, the superintendents, as well as the property owners understand the process, the different roles that individuals play, and in particular here, where are the input places for farmers and property owners to provide input into the project, as well as the decision points that council makes, and then ultimately where are the appeal mechanisms if things are not adequately resolved through that input process. As I mentioned, there are also improvement projects. So to touch here on briefly, there are now two types of improvement projects, one being major, the other being minor. So major improvement projects are required to address the needs of all or a large portion of the properties in a watershed. So there's a listing of some examples there, changing the course of the drain, changing capacity, etc. And this process requires the development of a new engineer's report. So this is very similar to the creation of a new drain where there's a new engineer's report. It goes through that complicated process that I showed on the last slide, allowing for input, council's decisions, as well as appeals to get a major improvement project done to an existing drain. There's also new as of June 30th, 2021, a minor improvement process, and this is detailed in OREG 500. And really, these projects are smaller in nature, and they are meant to address the specific need of one property owner rather than the entire drainage system. And so they're designed to allow projects to be completed quicker and more cost effective where a property owner needs a change to the drain, but really it doesn't involve anybody else. And so in this case here, examples might be a farmer needs a wider crossing to accommodate some larger farm equipment, perhaps a second crossing, or even relocating the drain on their property. So here on the bottom right is an example where the drain can be relocated on the one property to allow for greenhouse expansion as an example of a minor improvement. We have a fact sheet available on our website that walks through what is a minor improvement. There's been a number of these projects that have been implemented since it came into effect in 2021. And I think there's a lot of value for some farmers who want to do quicker things on their property that benefit only them. One of the things about this particular process is the farmer who's requesting it is the one who's benefiting. It's for that property only. And so the costs are paid by the farmer themselves, but it does allow for, again, that process to happen a little cheaper and quicker than the full major improvement process involving the entire watershed. Maintenance and repair is another very important piece. So again, the Drainage Act, Section 74, authorizes and requires the municipality to maintain the drainage system on the behalf of the property owners. So there is a form 0202, that can be found online to request maintenance of the drain. And essentially, farmers that need that to happen can go to their local municipality, submit the form, and there's a mandatory requirement that the municipality looks at that form and considers whether work needs to be done. And if so, they need to do the work, or there's some potential liability if they don't perform the maintenance work and it causes damage or crop losses from that lack of action on behalf of the municipality. There is a detailed process that the superintendent follows. So as I mentioned, they are required to follow up. In some cases, there may not be, in the municipality's opinion, a need for maintenance, but generally speaking, they're very diligent at going through the process. It's important to understand what the difference between maintenance and improvements are. So maintenance and repair is really putting the drain back into its original designed and installed conditions. And the existing report is what governs that. So how deep they can dig or how far they can remove sediment is covered by that engineer's report. And the costs as well need to be assessed out in accordance with that. So the engineer's reports will assess the cost for the original construction, and they'll also have separate schedules to assess the cost of future maintenance and repair. And that's what the municipality, the superintendent, is required to follow as far as the cost share for maintenance activities. Again, I won't get into the detail here. I'm happy to make this slide deck available through the OFA for distribution. This is a sort of standard process the superintendents follow when they get a maintenance request. So they consider a lot of things such as, is it a drain, yes or no? Can I do some repair? Does the engineer's report allow me to do the work I need to do? And then one of the really important ones is the assessment schedule fair and usable? Is it been set up in a way that if I do this work, it's going to be fairly assessed to the property owners who are getting the value for that maintenance work? So it kind of lays out the way the superintendent navigates those requests coming in for maintenance and repair. Touch briefly here on the ADIP program. So ADIP grants themselves, these are authorized by the Drainage Act under sections 85 and 90. And generally, we at OMAFRA pay grants towards any assessments made on agricultural land for drain repair and maintenance projects, for construction of new drains, for improvement projects as well. So in Southwestern Ontario, it's a 1/3 grant against eligible assessment costs made against agricultural land. So if you're a farmer and you're assessed under the Drainage Act for this activities, the municipality will apply directly to OMAFRA to apply that grant to offset some of the costs of your assessment. As well, we provide grants to the municipality directly to help them offset the cost of employing a drainage superintendent that does the maintenance and repair activities on your behalf as landowners. A little bit of context here. So grants, again, as I mentioned, are applied by the municipality. We see about 40 to 50 new drain reports coming in for grants across the province each year, about 125 improvement projects across the province each year, And really the big one is the maintenance and repair of existing drains at about 2,000 to 2,500 projects per year. And so we also have an agricultural drainage infrastructure program, and we have policies around that that really define what is eligible for grant. Most of these things are available as well online, and you can find that there, although I'm just realizing that the link that is in this slide is outdated, so I'll update that before I send that along to OFA to find the ADIP policies. Real quick, other types of drains that you may come across are award drains. These are drains that were done prior to 1963 under the Ditches and Watercourses Act. And these can no longer be constructed since 63, but there are some of them still in existence across Ontario. And so they are, if they're there, they're still legal, and they can be maintained by the owners in accordance with the award. And so really these are sort of older systems, and they stay there until they're petitioned to be brought under the Drainage Act, which occurs quite often when somebody does to do maintenance under them. They may consider bringing it by petition under the Drainage Act, but just to be aware that these do exist, and you may have a property that is impacted by that. Mutual agreement drains are another way in which drains can be constructed. So as I mentioned, the conflict between neighbors can be somewhat avoided by not going to the courts, by not petitioning for a drain. You can develop a mutual agreement drain, which is a private drainage system that authorizes the construction and financing and maintenance through a written agreement. The Drainage Act has Section 2 of the Act that describes what needs to be in this agreement to make it an agreement drain. And then the agreement itself may be registered on property title. And what that does is if it's not on title, then it's binding to the original signatures or the two property owners that have agreed to this. And if it's registered on title, then it's binding to all future property owners. So it encumbers the property and guarantees the rights of drainage that were agreed to by the original owners in perpetuity on the property title. As well, we have a fact sheet that explains what these are in more detail, as well as the advantages and disadvantages of them. So again, make yourself available to that if that's an option for yourself. So a few sort of general Drainage Act property owner types questions. Is there a drain on my property under the Drainage Act? How do I request maintenance? Can the drain be abandoned? Can I put a pipe in place of the ditch? There's a number of things that come up. I'm going to try to give some good background information on a lot of these in this presentation and through the question period at the end. But generally speaking, I'm available, OMAFRA is available to try to answer some of those questions, as well as your local drainage superintendent who's employed by the municipality. But really the Drainage Act is a powerful resource and a tool to address some of these specific questions and concerns that you may have. So common questions and drainage conflict. One of my favorite quotes is attributed to Mark Twain in the US, "Whiskey is for drinking, water is for fighting over." And generally, I think at that time frame, it was a lot about water shortage and drought in the Old West. And in Ontario, I would argue that water conflict is more about excess water and drainage than it is about drought. But certainly, we need the right amount of water at the right time of the year, and we do experience water shortages and drought. So I don't want to minimize that. But obviously, as the drainage coordinator, I want to talk about excess water and drainage. So some common questions between rural neighbors that we want to try to answer in this next little section here is, can the municipality stop me from putting the water from my tile drainage system into the roadside ditch? It goes that way naturally. Can I use the roadside ditch? A continuation of that question. Can my neighbor stop surface water from my land from coming onto their land? Other questions, if my neighbor refuses to share in the cost of a drain or a mutual agreement drain, can I just dump the water at the fence line? What can I do to make my neighbor clean out the ditch? And I'm sure there's a whole bunch of other questions. These are just some of the more common ones that I get. So I did want to address roadside ditches specifically and then get into some other concepts here as well. So roadside ditches can either be, as I mentioned, a private drain, which is designed on the road right away for the purposes of providing drainage for the road. So that's what I mean by private ditch. It's owned by the road authority. It could be the municipality, could be MTO, it could be the county, it could be a number of different owners, but the infrastructure is there as private for the road drainage. It could also be part of a mutual agreement drain, which I've seen in some cases as well, or it can be a drain under the Drainage Act. And really those three different legal definitions help determine, can I put my water there? So if the roadside ditch is not under the Drainage Act, there are some options. The road authority could allow you to do so. They could give consent to outlet your private system into the roadside ditch, but they don't have an obligation, as I mentioned, under the common law to accept water from an upstream property owner. Even though the water flows that way normally, if you collect it and discharge, there could be some potential lawsuit issues. Some municipalities, though, I know do allow connections completely without conditions or approval. Others allow these connections with certain conditions and an approval step. And some, quite frankly, don't allow connections at all. So it's important to understand, if you want to use the roadside ditch as an outlet, to have a conversation with your municipality to understand their approach, as well as understanding what is the legal framework for that particular drain that runs across the front of your farm. So as I mentioned, if the municipality does not have a Drainage Act drain across your road, there are just some things here that the municipality needs to consider. So this slide is really meant more for the municipality to look at. Should we have a policy on this? Does that specific roadside ditch have enough capacity? Would it cause flooding on the road? And there's a number of things that need to be considered. Is the roadside ditch deep enough to allow connection to the private system? Do they have an incentive or a desire to lower the inverts at the ditch bottom or culverts to allow those connections? So those are things the municipality really considers. My message here to the property owners is get in touch with your municipality if you are looking at using the roadside ditch. Get that conversation up in front of installing your system. Some other questions. So how do I get an outlet across my neighbor's property? So sort of approaches, good neighborly relations and discussions for an informal agreement. Can my neighbor and I agree to a handshake agreement? Is there permission to use the roadside ditch? Do we want to register my neighbor and I a mutual agreement, either with or without registration on title? So can we agree to what this might look like? Things like that are important to try up front. They can be cheaper. They can be ways of getting drainage needs accomplished and protecting those rights of both you and the downstream neighbor, or your upstream neighbor if you're on the downstream side. And then as well, a petition for a drain under the Drainage Act. So as I mentioned, if you look in that little schematic on the left, it says a municipal drain. If there is an option there, you could put a mutual agreement drain across your property owner B and C if they like that. The other option might be petition for a municipal drain branch extension by property owner A. So they could look at getting now that riparian right that they don't have in place by the petition process and building a drain up through property owner C, B, and allowing an outlet on property A. So that's just an example of looking at how do you get outlet. We talked a little bit about this as well. Can my neighbor stop my water from flowing? So in general, as I mentioned, surface water under the common law that doesn't have a defined channel, not in a natural water course, has no right of drainage. And so really the lower owner does not have to accept that water. So you'll see the sort of general approach from left to right on the bottom. Some of that uncollected surface water is probably not going to cause a lawsuit issue because it's not collected. The higher property owner doesn't have a liability likely, but the lower owner on their own property could berm that and protect their property if they didn't want to collect that water and allow it onto their property. So again, that could create some conflict between neighbors, but that is within the common law itself. Again, here, can my neighbor stop from coming on my land? Again, if they're collecting that water, it could be grounds for a lawsuit. So again, before putting in an agricultural drainage system, looking for outlet from a legal perspective, and then also from a sufficiency perspective. I'm going to jump through some of these quickly just because I'm cognizant of the time and I do want to make sure we have enough time for some questions. So I will just sort of jump through a few of these. And again, I'm happy to make these slides available. So just give me a second here as I just jump through a few of these here. So this is an interesting one. I'll just touch for a minute on this one. Can I make my neighbor clean out the ditch or creek on their property? So in this case here in the schematic, you'll see an example where there is a blockage occurring on the downstream section there that's causing some flooding on an agricultural property. And the question is, can I make my neighbor clean it out? And it comes down to, again, that legal framework is what is the legal nature of the drain? Is it an award drain, a drain under the act? Is it a natural water course? And so that is the first part of the conversation. And then is it caused by property owner action or is it natural? And so those sorts of questions come into a whole array of beavers on natural water courses are natural. They're not necessarily able to be forced to have that cleaned out. But drains can be managed by the superintendent. So it does fall on that legal framework for the drain and then who's causing the issue. So if you have sort of these scenarios, again, reaching out to your drainage superintendent to see if they can assist you, as well reaching out to our material online to see how potential solutions can be determined. And I'll pass over some of that as well too. Touching here on some resources. So as I mentioned, we do have some resources for various audiences. We have a guide for engineers working under the Drainage Act. This is a very specific guide that's meant for engineers working under the Act. It's available for purchase there, but generally the audience are practicing engineers. Guide for superintendents working under the Drainage Act is the second part in this publication trilogy. And it's focusing on the superintendents on how they do their work. This is available both in hard copy and downloadable PDF from Publications Ontario. This has some information that is a little more useful to the property owners, to the farmers in general. And then I would also reference in draft format, we are working on developing a guide for property owners involved with the Drainage Act. So we do have some fact sheets on our website that talk to a lot of these sort of general issues of the Drainage Act and as well as common law and conflicts, but we're trying to develop a more comprehensive property owner's guide that would be available. I'm not sure when, but in the next year or so, that may be beneficial for property owners who are working through these processes. As well, you may be aware of our Agricultural Information Atlas or Ag Maps. It's a great resource for showing where municipal drains are located as well as existing tiled properties. So we get records from our contractors every year and we try to record the tile drainage records up on our website. So if you're looking for outlets, this is a great place to start, as well is a piece of property tiled by a contractor. If you're looking at purchasing or understanding how these systems work, this is another resource for that. And then I'll end it there and open up for questions. This is also the slide that shows our drainage unit. So my own contact information there, email and phone, as well as Andy Kester, our drainage analyst and inspector. We also have another analyst, Kalita Atah, and we have Becky Kern, who's our admin service rep. And so all four of us work together as well as our manager on providing a number of these drainage programs as I've gone over here. So I know that was a quick flyby of a lot of stuff. I'm not sure generally where the interest is, so I'm happy to take any questions that are of interest to the audience.
Thank you so much, Tim. Maybe we'll start with the chat. There are a couple questions and then we'll get to the raised hands online. So the first question is, can you explain the rules, if any, in regards to force drains? We have one running the length of our property and a neighbor in the middle. It then crosses the road through one property where we're allowed to keep to remove beaver dams. Then the drain turns, briefly crosses another property where the new owner does not allow the removal of beaver dams. Historically, the dam has been removed with full approval of previous owners. The drain's probably 100+ years old, and then it outlets into a nearby creek. So I guess the biggest question revolves around removal of beaver dams.
Yeah, so that's a great question. So it depends upon what you mean, I guess, by forced drains. I'm not sure, does that mean it's a municipal drain or whether it's just a ditch that was dug privately? So it depends on the legal framework. What I'll answer is if it's a municipal drain under the Drainage Act, the engineer's report adopted by bylaw will outline what is the extent of the drain, how far upstream and how far downstream does that drain exist. And within the realm of those limits, the superintendent can go in legally and remove beavers from the drain. So in some cases, I know a drain is for a certain section, it outlets to a natural water course, and then beavers would dam that lower natural water course section of the drainage system. And that is where it's more challenging because the superintendent doesn't have authority to go onto that private property and remove the beaver dam. And so it's up to the private property owner to allow access or to remove the dam themselves. So some potential examples would be working cooperatively with the neighbor, which I know now it seems like it's changed with ownership, but also there may be options to discuss with your superintendent. Is there ability to extend the drain legally to exist where those beavers are currently making the dams potentially, and allowing the superintendent to go in and remove them? So it is about the legal limit of the drain that the superintendent can act within. And on natural water courses, there isn't a requirement for property owners to remove beaver dams. There's been some court decisions on that. And so basically that's your process, is extending the drain or working cooperatively with the property owners.
Great, thank you, Tim. Sandy, if you'd like to come off mute, and you're welcome to turn on your camera if you'd like to ask your question.
Hi, yes, can a municipality assess a property 100% on two separate drains versus just one? Like, can you be assessed 100% of your land to drain down two separate municipal drains?
So the general answer is no, because your water, you only have 100% of your water, which is kind of to your point, right? So certainly farms can be split between drainage systems. But the sum total of the percentage should be 100%. So you shouldn't be charged for 120% or 200% of your water. There, in some cases, can be a split, though, between the way surface water flows and the way groundwater flows, or collected water from tile systems. So I have seen where there is an assessment of 60% surface water to one drain, 40% to another, and a different ratio to another drain. But your general question seems as if you're being charged for more water than you're generating, is by the sounds of it. So my suggestion would be to work with your superintendent to see about getting that drain corrected so that those assessments are accurate with regards to where your water goes.
Oh, yeah, well, it's going to a tribunal right now, but just because we've been, it's gone to, for two different drains, we've been assessed, and unfortunately we can't come to a conclusion. So we are in the process of going to a tribunal, but we're uneducated on how all this works.
So the other thing that I would say, though, is if drains are in series, then if you drain into one drain and then that drain goes to another one, you can be assessed into both of those downstream drains because your water is passing through and you're using those subsequently downhill. So my comment earlier was about if you're at the top of a watershed and you're split, some of it goes east, some of it goes west, that's where you can definitely make sure that you're not being charged more water that isn't going into each drain. But it's possible in series you could be assessed into more than one.
Okay, thank you.
All right, we'll move on to the next question. Can one acquire a prescriptive right to drain water if both properties are registered under the Land Titles Act?
That's a great question that I don't know the answer to. What I can say is the prescriptive right process does require going to courts, and I mentioned those unchanged conditions, uncontested for 20+ years. I don't know how the Lands Title Act or other mechanisms of property ownership affect that. That's something I don't have any information or knowledge of.
Bob, we can go to you if you'd like to unmute.
Yes. When a municipal drain doesn't have time to heal because of a quarry or a wastewater treatment plant forcing water into it, it causes silt issues. Who is liable for the clean out of a municipal drain?
Right. So the maintenance of a municipal drain is, I mentioned, completed by either a property owner requesting the maintenance, or it can be done by the superintendent, going through and proactively inspecting the drain and saying, oh, there's sediment here, I need to clean this out. When it's initiated and done, if it's being done in accordance with the existing engineer's report, which determines how deep they can go to remove the sediment, etc., it also has to be assessed in accordance with that engineer's report. And so from a general maintenance perspective, it would be assessed out on a cost percentage basis, like the assessment schedule in that report would say. And it's assessed either as a percentage per property, or sometimes it's assessed with a dollar value, but it's still ultimately a percentage. And it's assessed out upstream of the work that's done, because the thinking is sediment travels downstream and deposits. So if you're downstream of an area that needs to be cleaned out, you wouldn't be assessed. Only those that are upstream are assessed in proportion to what the engineer's assessment schedule says. There are other mechanisms under very specific situations. If somebody does something and it's very acute and can be directed at a particular property or activity, I'm thinking if someone, goes and dumps soil on the edge of a drain and a big water rain event comes in and washes a ton of that sediment in, there are other mechanisms under which the superintendent, not under 74 maintenance, that they could use and try to get that cost recovered to a particular property owner. But generally it's assessed in proportion upstream under the engineer's assessment schedule.
My other question is, do you make site visits?
Generally, I don't personally know. Certainly I can help with processes, getting information out to individual landowners, and then pointing you to some potential conversations or points you might want to raise with the appropriate superintendent or things like that. But generally, I don't go out and get involved with individual projects that way, no.
And none of your other partners do that either?
Well, generally, no. I mean, so certainly I'm open to have a conversation or an email conversation if there's a specific request. But in general, the answer still generally is no. But I'm not saying it's an absolute no. It depends on the situation that's at hand, Bob.
Okay, thank you.
Okay, we will move on. We have kind of covered beavers. This one is, does a property owner have any recourse for flooding by downstream obstructions in natural waterways? And the example is beaver dams, debris, or fallen trees.
Yeah, so with the caveat of it being a natural water course, the courts have generally been reasonably clear that beaver dams and even fallen debris natural processes are expected on natural water courses. As I mentioned in the common law slide, you have the right to drain into a natural water course, but you do also have an obligation or a risk of accepting flooding when you're on a natural water course as well. So generally, it's about working with the landowner or who can have access and the ability to go in and remove those debris. But generally, natural water courses are not managed. They're regulated by the Conservation Authority, but they're not actively managed. So some of the recourses on that would be working with the municipality. You may want to consider getting that converted to a drain for beaver dam control, as an example. If it's perpetually having beaver dams, the Drainage Act process could allow the drain to be set up, and activities in the future might be beaver dam removal. I know that has happened from time to time, specifically for that purpose. The fallen trees, again, is really that natural occurrence, and it's a matter of trying to work with any property owners where those trees are to see if they are willing to go in there and remove those trees or blockages.
How can we confirm if we have a drainage system installed prior to the 60s?
Okay, so maybe Valerie can confirm this. So when you say drainage system, Valerie, you're referring to a communal system, right? Not your private ag system, is that correct? Okay, I'll go on that assumption. So in order for a drain to exist under the Drainage Act, it needs a couple of things. As I mentioned, it needs to have a bylaw at the municipal level that adopts an engineer's report. And so really to have a legal existence, you need both of those. Many municipalities have both of those for drains that go back a lot earlier than the 60s. Some of them go back, obviously the longer they go back, sometimes the records are harder to have, especially with different geo townships amalgamating and transferring offices over the years, et cetera. But generally it starts with a conversation with the municipality. Do they have a bylaw that adopts an engineer's report under the Drainage Act? And that's really the start of the conversation. you can take a look on our ag map site and get a sense as does it show a drain there? But ag maps is really just the first step, because if there is a drain on there, it would still need to have the bylaw and the report to have legal existence. And if it's not on our ag map system, again, if it has the bylaw and the report, it would give it legal existence regardless of what we have on our website.
Valerie, did you want to chime in with clarification for Tim, or did he answer your question?
No, he did actually. It was really to understand if we've purchased a property about 20 years ago and trying to assess what was historically approved or not on that property. So I was really curious about the reference that he had made around this notion of grandfathering some drainage systems. So he did answer the question. Thanks, Tim, so much.
Okay, thank you, Valerie.
Okay, next question online. Our farm has a municipal drainage ditch that starts 50 feet before our farm. There's a newly approved development with a stormwater drainage into the ditch that drains into our pond, which we regularly irrigate our crops. How do we move forward to protect our business?
So I'm just sorry, rereading that again as I was listening to it. There's a lot of specific information there. Drains into our pond. Okay, so part of the question, it comes to try to understand what is part of that municipal drain. So as an example, is the pond itself that's on your property that you irrigate your crops with captured as part of the drain in the engineer's report? If it is in the engineer's report, then that is part of the drain, and the individuals have, through that process, bought into the right, if you will, to drain into your pond. If it is not in the engineer's report, then the question is, how does the pond get water from the drainage system, and is there something that you could do to stop water from coming into your pond from that drainage system? So it really depends on, is that pond part of the existing engineer's report adopted by bylaw? The other, and that conversation is really about going to the municipality, getting a copy of the drainage report and looking at where are the legal limits of that drain, and does it include your pond. The other thing I would say is if the pond is part of the drain, then the conversation would be along the lines of, is there a way of removing it? Could we do an improvement project that would change the course of that drainage works to bypass my pond? And so that would be a conversation with the municipality and perhaps initiating an improvement project to change that drainage system to improve it from your perspective to have a different function of that pond. But I don't know if that pond is being used for retention and storage as part of the drain, or whether it's just happens to be a connection that you're concerned with because of things coming into that pond from the drainage system.
Great, thank you. Is the road ditch allowed to outlet onto our property, or can we block the entrance of this water?
That's a great question that I get all of the time. So basically, if you look at the idea of common law and water being surface water, not having the legal right of drainage, the road itself is a private piece of property, even though it's owned by the municipality or MTO, et cetera. And they don't have the inherent right under the common law to drain downstream onto other properties as well. They need to also manage their water either on site or get a legal and sufficient outlet for their road water. And so roads often will petition for a municipal drain that gets constructed and ultimately conveys the water down to the drain and then continues downstream without causing problems. So that's the legal framework side of things. I do know, however, that many times across the province, roads will put a ditch in to manage their own property. Those ditches aren't always maintained well. They may not even been designed well to convey water downstream to a natural water course, and so they overflow sometimes the year onto private farmland. In some cases, roads will put cross culverts in, taking water from one side of the road from one farm to another. These are all, from a common law perspective, potential liability issues for the road, because they don't have an inherent right to drain onto the farmland either. So that's the first part of the question. The second part is, could you block the road? And so under the common law, you could, in theory, on your own property, block your upstream neighbor, whether it be a road or another farmer, by building a berm and protecting that, provided you're not trespassing. That would have to happen on your property, not on your neighbor's property. So that's a possibility. And then the third piece is, I always caution when I hear people considering blocking the roadside ditch, is the potential liability if something were to happen to the road, right? So imagine you go and block this. Did you have the legal right? You might have. If the road floods, if it floods and freezes, if there's a life-altering accident because of those actions, you still could be liable. So you might be in the right from the common law from drainage. I'm just always really cautious, and I don't typically recommend people block water coming from the road authority. Generally recommend trying to work with them, or in theory, even petitioning or working with them to petition for a proper outlet for that water. So long-winded answer, but I'm always cautious around blocking road outlets.
There's another one here. What is the process in getting the township to lower a culvert that crosses a road to improve the depth of the ditch for tile to be installed?
Yeah. So it starts with conversation to understand what is the municipality's roadside ditch and private drainage coming into it. What's their policy? So that's where I would start the conversation. And again, some municipalities have an absolutely no, we do not accept any outside drainage into the roadside ditch. Others will consider it. And so the conversation is important with that municipality and the road authority to understand where are they on that spectrum, and are they willing to entertain doing so. I know in some cases, some municipalities are quite cooperative and they'll do that work. Generally, they're not, unless they see value in lowering that culvert for their own roadside drainage as well. Other cases, I know roads have entered into mutual agreements with property owners that want to use it. So that's an example where they request that the municipality with the road authority and the property owner generate a mutual agreement that talks about who's going to pay for this lowered culvert. And sometimes they are happy to then accommodate with a payment system in place through that mutual agreement process. And the other option is, again, petitioning for a drain if you're not able to get them to agree to those conditions of lowering the culvert or allowing your water into the ditch at all.
We have another question. Would any surface drainage uncontested for 20 years be able to go to court for prescriptive rights? The example here is the municipality has changed their roadside ditch cleanout practices, and they're now leaving the cleanout material on the field side of the ditch. Could the landowner that is now experiencing surface flooding go to court for prescriptive rights?
So the answer to that in general is yes. I think they could go to court for that. And again, my caveat with that is I'm not a lawyer, and it is a court process. So the court is the only one that can decide the prescriptive rights. But what I'm gathering from that particular argument is my water has always gone that way, right, into that particular location, unchanged, uncontested for 20 plus years. And now the lower landowner has blocked it. And that's essentially the same as if a farmer blocked another farmer by building a berm. So I think the argument is similar, and it sounds like a reasonable approach for a prescriptive right application. But again, I certainly recommend talking to a lawyer on that regard, because it is a court-based system. And so I'm not really giving legal advice in that regard here, but it sounds consistent with what I've seen other people go and consider getting a prescriptive right court order. Yes.
Another question, and I guess there are a couple of components to this. I have an open ditch running through our property. So first part is, how do I determine if the ditch is considered under the Drainage Act or a natural water course? And then my intent would be to investigate replacing the open ditch with a pipe.
Right. So in terms of what is the legal status of that drain is talk to your municipality to see if it is a drain under the Drainage Act. They manage those. They know where they are. They would have a bylaw and an engineer's report. If it's a drain under the Drainage Act and you want to improve that and improve enclosing it from your agricultural perspective or from your property value perspective, working with them to see whether that would be a major improvement process and how you would initiate that through the Drainage Act. I mentioned the minor improvement process talking about enclosing, a minor improvement process about improving or changing the drainage works on one property for the benefit of one property. There is some conditions in the regulation that goes with the minor improvements that basically does not allow an enclosure to be deemed a minor improvement. So you may have to go through the major improvement process, even though it's just on your property, but having a look in a conversation with the superintendent would be the best suggestion for that. If it's a natural water course, then you're going to want to talk with the local conservation authority as a starting point to see would they have any concerns with you doing that work and what would be required from a permitting perspective. And then ultimately, whenever you're changing an open ditch that has infinitely more capacity than a pipe, making sure that you get professional advice on how to size that so it would be appropriately sized to not cause an obstruction and cause flooding upstream of that potential enclosure.
There's a very specific question from Tom, but maybe we can deal with sort of in general. A drain, the farmer is a small landowner compared to the petitioner of the drain. The drain failed a week after the engineer signed off on the drain to make repairs for both the failed costs and improvements going to be significant costs. And what kind of recourse does a farmer have where the drain failed, especially this close with it being built?
Okay. So the dates in general, so once the report is adopted by bylaw and they tender it and they build it, the engineer basically certifies the project complete by a certain date. And that date starts a 1-year warranty period, if you will. And it's similar to any other type of tendered construction project. Under the Drainage Act specifically, though, there is a 1-year appeal period where any landowner can appeal the quality of construction on a drain. And that goes into the municipality through a form. And it eventually is considered by the Agriculture, Food and Rural Affairs Appeal Tribunal through that process. So I'm not sure if the 1 week after engineer signed off is within that 1-year period, and if so, that's something I would consider you to take a look at. If it's 1 week after the 1-year warranty period is up, then that's a trickier conversation because I don't think there's a built-in process for that. Certainly the frustration around all of this money being put into a system that failed after 1 year, these things should last longer clearly than 1 year. In fact, their service life is built out in a huge number of years. We're talking decades, right? So I'd have to give some thought to that. And Tom, I'm open to an email or a conversation in terms of what other options might be available. So, avail yourself of my contact information if you want to follow up with me directly on that.
Quick answer on this one. Do all municipalities have a drainage superintendent?
Not every single one does. The majority of them do. You can access that through our website as well. So we keep a list of on like a GIS Google Maps kind of platform that you can access the contact information for your superintendent. And if it's blank, it means you likely don't have a superintendent. Obviously, you could also Google or reach out to your municipality. There are most active municipalities have superintendents. There's approximately 150-ish. I don't have the exact number in front of me. Municipalities that have superintendents. Some that don't have a lot of drain activity. And so they have to then scramble to figure out what do we do to manage these drains if a maintenance request comes in, but most do.
Is it legal to have ditches empty directly into a main water course?
Is it legal? Sorry, could you repeat that question again, Joanne?
It says, is it legal to have ditches empty directly into a main water course?
So generally, yes. As far as like the common law drainage side of things, yes. I'm not sure what directly means, I guess. I'm not sure whether there might be other environmental legislation that would dictate how to stop erosion and things like that. I'm not 100% sure what the direct connection is referring to there.
I'm sorry, I'm just trying to go through. Do you see any other, Tina?
Um,
I'm sure we've missed some. I just,
There's one good one for clarity. Here is the drainage superintendent different from the road superintendent in the municipality?
Great question. So they're two different functions, but in some cases, the same staff person can be appointed both as the drainage superintendent as well as the road superintendent. And I don't have a listing of that because I don't have a listing of the road superintendents, but I do know that drainage superintendents in some municipalities wear multiple hats that can include the road authority, road superintendent hat as well.
all right. I am just
Thank
gonna
you.
ask, unless there's something else, Tina, do you see anything? We've already
No.
kind of gone over time. I did schedule this meeting till 1:30, but did not intend to go all the way through. I just knew that 1 hour for this drainage probably wouldn't have been enough time, and it looks like it wouldn't have been. So it's good that we did extend it a little bit. But we don't want to take up too much of people's time. So I think we are going to wrap it up now, unless Tina, do you see anything?
Nope, I will just add that I've added my contact information as well to the chat if anyone wants to contact me. And again, Tim's information is there. It was also mentioned in the chat in terms of accessing this recording and the slide decks and materials that it will be posted on OFA's site. So there will be access to the materials after this.
Yes, if you go on our website, ofa.on.ca, you'll see resources along the top, and then there's a drop-down menu and it says webinars. So if you just click on that, you will see this one along with all of the other ones that we've done, which have been a lot lately. And Matt has put it in the chat, a direct link to the webinars on the chat as well. So thank you, Matt, for that.
And if we have missed your question in the chat, please reach out to either Tim or myself, and we can discuss it in more detail.
And I do think there was one question up further, resources other than this presentation and the recording. Where would they find like 10 top like the common questions about drainage? Where would they find that, Tim?
Yeah, so we're currently in a little bit of a transition. We used to have a main landing page that has just recently been taken down. So we're working really hard to get up a new landing page, and I'll provide that to OFA once it's available. You can go to www.ontario.ca, which is the main government page, and search. And so it's a little bit more tedious than it used to be, but if you know what you're looking for, you can find it. And as well, if there's something you can't find, again, feel free to reach out to me and I can try to point someone directly to that resource that is up and available. It's just not easy to find as it used to be.
And there were some very specific questions in the chat where I just kind of replied individually to some of those individuals, just saying that, you know, it's probably best to reach out directly. So you may get some phone calls later. Anyway, so thank you very much. This was great. Thanks, Tim. Thanks, Tina. This was wonderful. And yes, anyone can view the recording at a later date if they weren't able to join today.
Well, thanks so much for having me. I really appreciate it. And hopefully it was helpful for your audience.
Great. Thank you very much.
All right, thanks, everyone. Have a great day.